Dear students, in this lecture we will try to cover the leftover portion which remained untouched in the previous discussions with respect to chapter 16. This topic of rape as an offense and its punishment is provided in chapter 16, which we discussed previously, and this chapter we know that it is dealing with the offences affecting human body. We studied various offences starting from culpable homicide, murder, etc., wrongful restraint, hurt, kidnapping, abduction, acid attacks, etc. And this was left untouched at that time. In this lecture, we will try to discuss this last part. This offence of rape is falls under the caption of sexual offences. If you look at the bare act of the Indian Penal Code, you'll find that sexual offences have been enumerated from sections 375 to 377, with rape and its punitive provisions, etc., in 375 to 376E. And lastly, this is the lone section that is not incidental upon the rape. It deals with unnatural lust or unnatural offenses. So this is not our point of discussion today. We are going to discuss only the offense of rape. So offense of rape is pretty complex in Indian legal system. Rather, I have not known any legal system as complex as the Indian legal system with respect to the offense of rape. And it is complex not in terms of the definition of the offense, it's more complex in terms of the punitive mechanism or the punitive scheme of this offense. If you look at various reports of National Crime Records Bureau, etc., you'll find that previously in 2017 probably the NCRB data showed that in every 15 minutes a rape is committed in India, and the conviction rate in offences is only 27%, and it was probably 40,000 cases or incidents of rape were registered in 2016, and in 2017 only 34,000 were registered. So there is a horrific data which enables us that this is a devastating and most dastardly offense committed against a specific gender, and Indian Penal Code has adopted such a definition of the offense of rape, which you will find is not gender neutral. In this, the victim and the perpetrator both have been identified as per their gender. Victim is always a female. You will not find a victim to be a male. If the victim is male in case of sexual offenses, that is what I want to point out, it will be covered under section 377 and not under 375 or 76. There's a case of that is called Anil versus State of Maharashtra. I think it was a case of 2014 in which Supreme Court clearly and categorically delineated some specific remarks with respect to the offense of sodomy to be falling under 377. So if the victim is a male, it cannot be called a rape, because India's rape law is not gender neutral. You have to keep this in mind always. So there was a charge of sodomy, which is also called as pederasty in criminal jurisprudence. So cases of pederasty or sodomy, etc., when the victim is a male, note the point, when the victim is a male, will always be covered under 377. And in case a victim is a female and the perpetrator must be a male, if you look at the definition, we'll come back to that, but first we must analyze the overview of and the scheme of the punitive scheme or the punitive mechanism, which is very complex. If you look at the punishment provisions, there is an enormity of provisions, and rather it is too complex, or there have been many amendments with respect to the rape laws. That is why it's very difficult to identify where does the case fall. And the rape law in India is more reactive than proactive, because, for example, the gargantuan changes that took place in the laws of rape was the Criminal Law Amendment 2013, and you remember that this was Justice Verma, J.S. Verma committee, after the aftermath of this Nirbhaya rape case, and then there was 2018 Criminal Law Amendment, which included death penalty in certain cases of rape, and this also was a repercussion or a reaction following the Unnao rape case and the Asfa Banu Katwa rape case. So more or less, this rape law in India has seen major changes from the eruption of masses after the eruption of public. So let's look at the provisions of rape. The definition of rape, if we look, is provided in 375 only. Definition. We'll come back to this part after a while. The whole punitive mechanism must be understood under 376. These are only two sections actually, because after 376 you will go directly to 377, which is related to unnatural lust. And you know that in Navtej Singh Johar versus Union of India 2018, section 377 was read down. It was not struck down. When constitutional court strikes down a provision, that means this provision or this law has become inoperative and unconstitutional for all purposes. And when certain laws are declared unconstitutional or inoperative for certain purposes and not for whole purposes, such a doctrine is called a doctrine of reading down. For example, 377 is still a law in cases of non-consensual sexual intercourse against the order of nature and other incidents, but in case of consensual, in case of LGBTs, etc., this is not a law and it has been read down. So the whole punitive mechanism in case of with the offense of rape is provided in 376. So this is definition, this is punishment. But 376 itself operates at certain heads, and it's my duty to explain them here so that no confusion takes place further. So kindly keep making the notes of this chart that I'm going to draw right now. Look, if we look at 376(1), subsection 1, it is the general provision with respect to rape which criminalizes and punishes the offense of rape in ordinary courses. 376(1) makes the offense of rape punishable. I'll write it. It is punishable with an imprisonment of which shall not be less than. I would say less than, and this is not. So this means not less than, because I will keep on repeating this in the whole lecture so that you get it properly. Not less than 10 years. And this may extend to life imprisonment, maximum to life imprisonment, and this shall also plus fine. Plus fine means in every case there shall be a fine. It's mandatory that fine shall be there. So this is very old law. I mean, 376 is the earliest without amendments. You'll find that there's not an amendment in it. Earlier, this is the law which stood there even before 2013 amendment. Then there is a specific form of this rape punishable under 376(2). It penalizes the case of rape by certain persons, category of persons. For example, police officer, a public servant, or member of armed force, or a jail staff, or a hospital staff, or a person who stands in a fiduciary relationship with the victim. For example, a relative or a teacher, or for example, any guardian, etc., or rape committed during a sectarian violence or communal violence, or rape committed against a person who is pregnant or laboring under pregnancy, or a case of rape. You must look all those grounds. Rape committed against a person who is unable to communicate the consent, etc. In all those cases, the perpetrator will be punished with an imprisonment of not less than. These all punishments of rape put a capping or a limitation on the punishment, that they shall always be more than this. So the punishment shall not be less than. Ordinarily, you will see the provisions of punishment starting with that they can be punished by with an imprisonment of any description which may extend to. So there is no limitation, lower limitation. But these all provisions of rape, you'll find that there are lower limits prescribed, and plus all the forms of punishment are rigorous. There is rigorous imprisonment. This is rigorous. This is also rigorous. There's only one place where you will find that the punishment is simple. So I'll mark that out. So under 376, when the perpetrator is a certain category person identified as police officer, public servant, etc., the punishment shall always be an rigorous imprisonment of not less than 10 years, and which may extend to life imprisonment. Sorry, in this case, this is the simple imprisonment. Yes, this is the whole sole case of simple imprisonment, simple or rigorous. It may be alternatively, but this is mandatorily a rigorous imprisonment. So this is 10 years rigorous imprisonment, which may extend up to life imprisonment, and there shall always be a fine plus fine. These are actually the first two clauses of this punishment of rape, but there was an amendment in 2018 which added 376 2, sorry, 3 in that. The third clause, which provides the punishment for the offences of rape when the victim is below 16 years. Below 16 years. So this is what is most controversial in the jurisprudence of rape laws in India, because it has prescribed a punishment which is age specific in terms of the victim, and which does not fit in the fine canons of the criminal jurisprudence, because for example, if the victim is below 16 years, the perpetrator will be punished with an imprisonment of not less than 20 years. Which shall not be less than 20 years and may extend to life imprisonment. This is rigorous imprisonment always, plus fine in every case. So this was added in 2018, 2018. So for example, if you look, there's a victim of 16 years and 1 month. How does she stand different from this victim only in terms of just a few days? So there's a little bit rationale to support these arguments that there should be a capping on the age, although there are some legislative exigencies also that persons of specific age need a special protection under the law. So you'll find that there are diverse provisions after this in which perpetrators have been punished as per the age. Now, this concludes, these are the three subsections. Then there is clause A, B, C, D, E. Those all provisions make the rape laws in terms of punishment very complex. We'll study them here altogether. We'll start with first, that is 376A. 376A was added after the Justice Verma Committee amendment of 2013, after the aftermath of this Nirbhaya rape case. So it penalizes and punishes those instances of rape where there is rape plus the victim is inflicted upon a hurt due to which the victim goes into a permanent vegetative state, PVS, permanent vegetative state, as in the case of, you must be knowing, well acquainted with the horrific case of Anura Ramachandra Shambang. You must visit the case of facts of that case, in which the patient remained in PVS for almost 41 years and she never regained consciousness, and she died after 41 years. So if the patient, if the victim turns into PVS, or if death takes place or death occurs due to that hurt, then in all those circumstances the victim, the accused shall be punished with an imprisonment of not less than 20 years, which may extend to life imprisonment, or alternatively he may be punished with death. So this is the first instance when the penalty of death was introduced in rape laws. Otherwise, before 2013, rape laws were not punished in India, punishable with death. So this is the first provision which gives for death penalty in offences of rape. So in 2018, the next subsection, that is 376A, B was added. Kindly make a good chart of all those provisions. 376AB. It was added in 2018, just 2 years ago, and it specified the victim again when the victim is below 12 years. If the victim is, there was in 2018 this 16 years in normal course, and this also 12 years. For that means if the victim is between 12 and 16, then this will operate. But if the victim is below 12 years, then the punishment, the accused shall be punished with an imprisonment which shall not be less than 20 years, 20 years, and which may extend to life imprisonment or death, plus fine. In all cases there will be fine, not in case of death, but this is the case of victim being less than 12 years. Then 376b, move ahead. 376b, quickly going through those provisions. This is 2013 amendment. If this is related to this rape being committed on a woman who is living in separation from her husband under the decree of a court or under any by her own consent. If she is living under separation, so the act of having sexual intercourse with her does not qualify to be a rape. So law does not call this a rape. Kindly note this thing. If you look at the bare language, it's not a case of rape, but the offender shall be punished with an imprisonment of not less than 2 years, and which may extend to 7 years, and fine shall be always in every case. This is 376b. And then we move ahead to 376c. 376c is also an amendment of 2013. If a person in authority does an act which does not amount to rape, this is also an instance which does not amount to rape. For example, there is a consent and consent was invalid, or for example sexual favors are demanded from a victim and she commits to sexual intercourse which does not amount to rape, and it shall not be called a rape. If there is an instance of such a case that it's not a case of rape. Yeah. So in extreme and remote circumstances, there may be an act of sexual intercourse by a person in authority which does not amount to rape. Then punishment is to imprisonment which shall not be less than 5 years and which may extend to 10 years, upper limit of 10 years, and this is rigorous imprisonment, and there shall be fine also. Now 376. Imagine this line is in continuity. What I am drawing. So next there shall be. You can pause the video at this place and complete the drawing. There is 376. I think D, A, B, C, as we discussed. There's D, 376D. This 376D which is the provision which talks of gang rape. Gang rape. You have to understand that this gang rape or instances of gang rape will be always read with section 34 of the Penal Code, that is where they commit the sexual assault in furtherance of their common intention. So when the perpetrator is more than one, this was added by the Criminal Law Amendment 2013. In case of gang rape, the punishment shall always be not less than 20 years and which may extend to life imprisonment. It's very catastrophic and strange to note that the legislative scheme must have been that there must have been a mandatory death penalty even in cases of gang rapes. But in 2013, the legislature has failed to meet the demands on these lines. So 376D contains two more provisions which were added in 2018. One is 376DA further, and another is 376DB. I told you already that these rape laws are very complex in terms of punishment, on the point of punishment. So if the victim is, in case of gang rape, below 16 years, these are the mirror provisions of this. If the victim is below 16 years, here in case there was the punishment of 2 years minimum. So the punishment to every accused in case of such a gang rape when the victim is below 16 years is life imprisonment. There is no imprisonment of any description. There is minimum imprisonment is life imprisonment plus fine. And there should have been another provision of death penalty. There was no consensus on this point amongst the parliamentarians on this point. So in 376 DB, when the victim is below 20 years, this is less than 16 years, this is less than 12 years, sorry, less than 12 years, the minimum imprisonment punishment is life imprisonment, which may extend to death. So this is another case wherein death penalty was introduced, that is in case of 12 years. So you note this down, that in case when a person or the victim is raped and she turns into permanent vegetative state, or death occurs by reason of an injury inflicted on her, alternative punishment of death has been prescribed. Then another provision providing for death is 376 AB, which is 2018 amendment itself, in case of victim being less than 12 years. And this is, I don't know how they stand different from the victims below 16 years. I mean 12 to 16, when the victim is 13 years, how is her chastity different from chastity of this person? This is a debate which can be set into motion, but must be restricted to academic discourse only. So, and then this case of gang rape committed upon a victim below 12 years of age, there is a mandatory, there is a alternative death penalty. It may be the victim may be accused may be imprisoned, punished with life imprisonment or with death. And lastly, 376 E, which was added in the last provision in this line, is 376 E, which was added in 2018 in case of repeat offenders, when the offender is a repeat offender, hence previously committed such an act and is repeating the offense of rape. And this is a very irony that many of those persons are found roaming around and have committed these offenses on occasions more than once, and in such a cases the courts are given the powers even to give the life imprisonment or an alternative punishment of death. Now this concludes the discussion with respect to the punishment. Coming back to the discussion with rape, definition of rape. So the definition of rape, I told you already, is victim specific or victim identifying. It identifies the victim always to be a woman and perpetrator accused to be a man always. So India's definition of rape is not a gender neutral, you know that, and that is why this definition of rape in India, you'll find, starts with the words and phrases that a man is said to commit rape. That is why it starts with the assumption that is a man is said to commit rape, and then you will find that victim is in every case is a woman. Now, before 2013, there was a blanket term that was used in the definition of rape, that was who has sexual intercourse in one of the 7 ways against the woman. Now, this sexual intercourse, this term has given way to the new phrases. There have been identified 4 means or 4 clauses under A, B, C, D. I will not go into the fine details of all of them, or any of them rather. You kindly look at the bare provisions, but I'll mention all the 4 means, because in order to cover the other methods that the perpetrators used, it was a lacuna law, because it used the phrase sexual intercourse and without identifying the means and methods of what amounts to having sexual intercourse. So for example, the new definition includes also other means of committing, for example, using external objects, etc., which was done in the horrific case of Nirbhaya. And you must visit the judgment of Mukesh versus NCT of Delhi, and fortunately all those perpetrators were hanged recently. So there are 4 means. Number 1 is, I'll write them down quickly. Number 1 is penetration, which obviously restricts to the male genitals, etc., into the female genitals, etc. And number 2 is insertion, This is the word which gave a wider ambit, so which includes foreign objects, etc. And number third is manipulation, and number four is application. These are the four means which you must study the definition. And if the accused, and if the man who he is said to commit the rape, if he does any of these things, not all of these, any of these things in any of the seven ways. There are seven ways which I will highlight quickly. Any of the seven ways. Any of the seven ways. These are the seven descriptions or circumstances, rather. It must be called circumstances. Yes, seven circumstances. And these all circumstances, these seven circumstances, dwell upon the theme of consent. Because consent is the only thing which compounds the offense of rape. It might altogether become adultery or become no offense at all, because adultery is not anymore an offense in India after the judgment of Joseph Shine versus Union of India. We'll come back to this, these seven ways. Number one is against her will. Against her will. And number two is without consent. There's a difference, subtle difference between the two, without consent and against will. Against will means when she has given or declined to consent, when the victim has categorically denied to get involved in that practice. And without consent may even include the circumstances when she has not exactly expressed any opinion about her, or she may not be in a position. For example, she is unconscious, or for example, the victim may not be in a position to state the consent at all. So this is the case of these two phrases increase the ambit of the consent, and these are without consent. Now, the following, I think three cases of consent are with consent. There may be cases of with consent, so I'll call them with consent. I'll write them like this. Number three is the first section, with consent. Even these instances with consent might amount to rape. The first instance is covered under this section, subclause 3. That is, when consent has been obtained by putting that person or the victim or any person in which the victim is interested in fear of putting victim or any other person in which the victim is she is interested in fear of death, or hurt. And you must remember that the word injury has not been used, because injury is a very weaker word to stand this ground, because injury includes also an offense against property and reputation, and those cannot be grounds in which a woman can be deemed to give consent. That is why these words, instead of injury, hurt has been used, not injury. You should remember this word, hurt, death or hurt. This is the case of first when sexual intercourse or any of the means have been administered to the accused with consent, but still they amount to rape despite the presence of consent, because consent is invalid. She has been put under fear of death or hurt. Number 4. This is another case when rape is committed despite the consent is present already there of the victim, because she consents due to a mistake of fact. She believes that the man to whom she is subjecting, this is a very specific and very peculiar of Indian society, because here the set of marriage institutions and institutions of marriage and etc. are very vulnerable from certain aspects. That is why you would think that it is hard to contemplate these circumstances, but practically they are possible given the scenario of the society in these nations. That is the case of when she consents because she believes that the man to which she is giving the consent is legally wedded, or she is lawfully married to him, and that man knows that he is not legally married to her. She consents. You must look at that due to a mistake of fact. because she recognizes him as her husband or legally married person, which he actually knows and which actually is not the case, and he knows that he's not such person which she believes to be. This is the fourth case. And the last case among this is, there are seven circumstances. Two of them are against her will or without consent. Three are despite her consent. First is when she has consented due to the fear of death or hurt to her person or to any other person in whom she is interested. Or she has consented because she believes that the person whom she is giving consent to is lawfully married to her, and that person or the perpetrator knows this fact that he is not that person whom she is believing him to be. And the fifth case is when at the time of the consent, here the time is material, when at the time of the consent that victim is unable to give the consent, or her consent is not valid because of certain factors. For example, unsoundness of mind. Unsoundness of mind, this is the first thing. I'll write it down more clearly. I'll write it here. And the first case is unsoundness of mind. This is the first case. Second may be because by reason of intoxication. Intoxication means voluntary, involuntary, all, even voluntary intoxication, because here the word consent must be read conjointly with section 90 also. 90 is the general provision with respect to consent, but here you will find explanation 2 probably, which qualifies the word consent also. So these two are the special provisions with respect to consent. So even a consent given in case of voluntary intoxication is an invalid consent, even if she has administered herself an intoxicating substance. Or third case may be in these, when she is at the time of consent, but this effect, that is unsoundness of mind and intoxication, all these effects must be present at the time when she has given the consent. If she has given consent at a time when she was normal or sane, then the question of validity of consent does not arise. So these all things put the consent, that is in unsoundness, intoxication, under the shadows of doubt. And the third is that when she has been administered what is called in medical law, medical terminology, stupefying or unwholesome substance, which deprives a person of sanity or senses for a moment or stupefies him. So when she has been administered by the accused himself or through any other person, stupefying or unwholesome substance, in all those cases, if she is unable to give a valid consent because of these things, so despite the presence of consent, the act of committing any of these four things against her will amount to rape. So now we concluded the case of 2, 3, 4, 3, 4, 5. So these three cases where despite the consent it amounts to rape. Then there is a case where consent is altogether immaterial. It is point number 6 in cases of immaterial consent, and that is in case when the victim is below 18 years, less than 18 years, because above 18 years a person may subject himself or herself to a consensual a relationship with any person under the Anglo-Saxon law. But immaterial consent is the case of person or victim being below 18 years. The consent is immaterial, whether with or without consent, it doesn't matter all. And lastly, there is the seventh case when the victim is, when she is unable to communicate the consent. For example, a patient in permanent vegetative state, or a person deprived of the speech, etc. And these are horrific social crimes taking place against a specific gender. There are two explanations attached to it. I'll dwell upon the explanation 2. You kindly look at the explanation 1 yourself. Explanation 2 qualifies the word consent. Explanation 2. Explanation, not an exception. There are 2 exceptions, 2 explanations, but remember I'm talking about explanation. Explanation 2 qualifies the word consent, and consent has been defined actually as an unequivocal statement where the person or the victim has given an unequivocal voluntary agreement against in or through gestures or verbal or non-verbal communication, her willingness to participate in the act. But there is proviso which is more important than this explanation of consent. The proviso is more important because proviso says that a woman who does not physically resist the act this of rape, it shall not be the only reason to conclude that the party was consenting. It's a very nice proviso, but it was counterbalanced in a very what Supreme Court called a well-written judgment. You must visit that judgment of Mahmood Farooqi versus State and City of Delhi. I think it was a judgment of 2017 where an accused was released and court dwelled. I think Justice Ashutosh Kumar gave a very well-written judgment. It's not my phrase. The Supreme Court used this phrase for the judgment of Justice Ashutosh Kumar, that it's a well-written judgment. And I personally found that it's a very interesting judgment on the theory of consent, and the accused in this case was acquitted, and Supreme Court appreciated the judgment, although many of the writers called it a travesty of justice. So consent is actually the basic factor which compounds or condones the act of all criminal acts, and rape being no exception to it. So explanation 2 defines the word consent. Lastly, now we come upon this case of exceptions, and you must bear in mind those both exceptions, because from the examination point of view, sometimes questions are asked on exceptions. This exception was included in 2013. That is number 1, that is medical procedure or medical intervention. Medical procedure, because the ambit of sexual intercourse was increased, so it would have tantamounted that medical procedures and interventions might amount to rapes, since the ambit was increased, because by virtue of those 4 means: penetration, insertion, manipulation, or application. That is why this exception first was necessitated, which holds that medical procedures or intervention shall not constitute rape. And exception 2, which provides that when a man commits the act of sexual intercourse with his own wife, the wife not being below 15, that means a man's sexual intercourse with his own wife who is above 15 does not amount to rape. This is the provision which invigorated and set a fiery debate of marital rape in discussions, and it is still being debated within the legal luminaries, but that is not seen a light of day. Courts have made remarks. In various judgments, courts said that marriage does not mean unceased submission to sexual intercourse, and the consent of woman is always material, and there is sexual autonomy concept of this. But many of the antagonists believe that it would be tantamounting to intervention and interference in the marital knots of the people, and letting the investigative and state mechanism to intervene within the personal lives of the couples. So yet it is not a law, but this is what compounds the marital cases of having sexual intercourse with one's own wife. So this is all about the offense of rape. You read the case of Mukesh versus NCT of Delhi and other judgments. There's a katina and plethora of cases that every year come before courts, and this is all about the offense of rape. If there anything remains, you may ask freely. Thank you.